The bill seeks to bring within its ambit all the three wings of government, legislature, executive and judiciary. And it also seeks to confer enormous powers on a body of 11 member or 9 member body called the Lokpal. There are many flaws in this bill, but according to me, one of the most glaring flaw is the inclusion of the judiciary. There is a bill called Judicial Standards and Accountability Bill, which has been introduced in Parliament. The bill is with the Standing Committee. Now there are some flaws in this bill. It has to be strengthened. I am all in favor of the judicial accountability, but that accountability cannot be enforced by a Lokpal who is overseeing the monitoring the certain ministers and the bureaucrats and the other bodies, ombudsman. So this is the first time, the Anhad's team is seeking to create a bill, is seeking to impose a bill on this nation whereby it's such a gigantic authority is sought to be created. So, I have not understood this. I can understand a demand that you need a strong Lokpal. I can also understand a demand that you need a Lokpal. But I don't understand this approach that if you don't pass you don't accept the bill prepared by a particular group, it should be, then there will be fast. I feel that this is completely undemocratic. Yesterday, which I read in Hindu, that one of the supporters of Anna, a close associate, said that Anna is India and India is Anna. I'm sorry that Hindu criticizes very strongly. These are I remember the emergency days when I was a young lawyer, when Barua said that Indira is India and India is Indira. But I must tell you one more thing. Anna is not civil society and civil society is not Anna. So I want to add that today, that the civil society is not only 5 members who can impose their will on the nation. So you have to hear the different voices of the nation. Now this Judicial Standards and Accountability Bill, I will just explain in 5 minutes. Today, if you want to remove a judge of the High Court or the judge of the Supreme Court on the ground of misbehavior, the only way is by bringing a notice of motion in Parliament, in Rajya Sabha by 50 MPs and in Lok Sabha by 100 MPs. So our experience is that it's difficult to get the signatures of the requisite number of MPs. So this bill seeks to introduce a complaint mechanism. Any citizen can complain against the judge and judge of the High Court or the Supreme Court or even the Chief Justice of India. And that complaint has to be investigated by a certain committee. The bill contemplates a 3-layered committee: scrutiny committee, then oversight committee, and inquiry committee, etc., etc. If the judge is found guilty in that particular by the committee, then the report of the committee will go to the president, and president shall place this report before the Parliament, and the Parliament will have to decide whether the judge should be removed or not. And this will be same process will apply. The other is that there are some indication in the Act that suppose it's not really a case for removal of the judge, there may be still a misbehavior, instance of misbehavior or a lesser misconduct. So the bill contemplates some sort of a censure or warning that requires extension. A serving judge of the Supreme Court, a serving sitting is a Chief Justice. My view is that all these persons should be selected not by the CJI, in the selection of the CJI, but the Collegium of Judges. Collegium of the Chief Justices will select the Chief Justice, Collegium of the Supreme Court Judges will select the Supreme Court Judge, and there will be 2 other persons. Now the 2 other persons are as per the present method, a jurist. Now you will recall that Mr. Mohan Gopal, a great academician, he is not a lawyer, neither a judge. He has been appointed as part of the committee of Justice Dinakaran's inquiry committee but now that issue is not there. But such academicians or some retired judges can be even considered, some jurists, even lawyers like Mr. Palinariman, or there are several other lawyers, they can be considered for this post. Then the fifth member should be an eminent member of the society, and to be chosen by, these two persons should be chosen by a committee consisting of Prime Minister, Leader of Opposition, and also the Chief Justice of India or his nominee. Then it should be a permanent committee. The judges should act on, sitting judges should act on rotation. They should have an investigating machinery. These are and this is how it should be strengthened. The other aspect is that this particular law says, the Judicial Standards and Accountability Bill, all proceedings should be confidential. I am of the view that it should be confidential only at the initial stage, till it is scrutiny. But if the committee finds that there is serious misconduct, then it should be, all proceedings should be held in public. Next is that there should be minimum, some light minor punishments. And one of the most important aspects which we have covered is that merely because the judge has demeted office, the inquiry should not come to an end. The inquiry should be proceeded with, it should be concluded, and if the judge is found guilty, then there can be penalties like his taking away his pension, he should not be again considered for any public post. So this could be done. Then also there is a provision that if you file a false complaint, if your complaint is turned out to be false or vexatious, then the person can be punished for a period of 5 years. This is ridiculous. We said that there should be some fine or a light punishment. It should not be more than 6 months. But you cannot prevent people from. This will be discouraging the people from filing complaints, and many serious complaints against the judges will not be considered.
कोई भी इस देश में करप्शन कोई आवाज उठे उसको सपोर्ट ना करे वो संभव नहीं है, मगर उसका नतीजा क्या है और उसका निचोड़ क्या है और कहां पहुंचना चाहिए उसमें फर्क है, और फर्क होगा क्योंकि हम उस दृष्टि से देखते हैं जहां हम खड़े हैं। और मेरे अनुभव से मुझे ये एक लोकपाल बिल में सारे देश के भ्रष्टाचार खत्म हो जाएगा या एक जादू की छड़ी है, ऐसे नहीं लगता है। और ये भी नहीं लगता है कि जो कानून वो बनाए वो कानून से ब्यूरोक्रेटिक जो बीमारियां हैं वो सुधरे जाएंगी, ऐसा लगता है वो और भी हो जाएंगी। इसलिए हम ढांचा दूसरा चाहते हैं, लक्ष्य तो एक ही है। वो लक्ष्य के लिए तो कोई लड़ाई नहीं हो रही है, भ्रष्टाचार को कोई नहीं कह रहा है कि कायम रखना चाहिए, हम सभी कहते हैं कि खत्म होना चाहिए। मगर हमें लगता है बहुत सारे और चीजें चाहिए, इलेक्टोरल रिफॉर्म्स चाहिए ताकि उस ढांचे में लोग बैठते हैं वो अच्छे हों, ऐसे और भी बहुत सारी चीजें हों तो ये देश सुधरेगा।
Using constitutional mechanisms, using institutions of parliament in which we can get progressive legislation, and there are ways and means to do it. Along the way, there may be issues that will come up where differences arise, and we have been through, and that's why we came to you, started off with our experience with the Right to Information movement, our experience with the NREJ, that it is not that any one formulation can speak on behalf of any of us. We do not agree with that formulation. If anyone were to say it, even one of our own friends, and there are many of our own friends in the IAC, we do not agree with the formulation that anyone can claim to speak for everyone and not follow democratic norms.
Of course, it also has to locate itself in the theoretical framework of an advisory body. And so far, government has not done a proper theoretical framework in which it fits in. But like the NEC, there must be other advisory bodies, but government has many advisory bodies, which it creates for special purposes. The NEC only advises on social sector issues. It cannot go beyond that. The mandate is only social sector issues, issues of poverty, issues of inequality, and issues relating to the marginalized. But we are only, as I said before, an advisory council. We cannot say we fight our battles in the open domain. Nikhil and I wrote against the CBI's exclusion from the RTI, but the NAC finishes for both of us after 2 days. Then we do our own work. So, but that role has to be clear. There's been some mischief which has made NCPRI part of NAC. Of course, Harsh and I, before we even conceived of ever being members of any advisory council, in 1996 were members of the NCPRI. If the NCPRI should say something, and then you say it is the NAC, then it is because probably we are a fairly illiterate country. So if anything starts with an N, we probably feel it's all the same thing.
No, only on the first. The NEC is an official advisory body. The government has an economic council, it has various other knowledge council, it has this, that. It's created a council of people it wants to advise on social policy and legislation for the poor. The two of us are members who can be considered civil society people, but they're officials also there, they're academics, there's an industrialist, there's a planning commission member. It advises government. I think there's no comparison. There's a legitimate role a government can seek advice. But likewise, there's a completely legitimate role for people's organizations of any kind to get together and think through policy and advice. So I think they are not mutually exclusive.
And secondly, I am really concerned about the judiciary, and I feel that I am not the only person who spoke on oppose this particular proposal. There are many from the judiciary, and I am not part of it.
So I leave it to all of you to investigate, to find out where the money has come from and how it's being spent, and how much has come, it's in the public domain.